Good afternoon.
Hello, everyone. Thank you very much for joining us today for our webinar on energy construction disputes. I'm very happy to present to you our two speakers, Ms. Olena Perpelinska and Pirik Legov. Unfortunately, Ms. Maristoyanov could not join us today for her professional commitments that arrived only yesterday. So we will be conducting webinar, three of us, Pirik, Olena, and myself. My name is Sergey Melnik. I'm a deputy counsel at the ICC dealing with Eastern Europe. So the first speaker is Olena Perpelinska, who is the head of international arbitration practice at Integritas, who is also a very active ICC court member, and I'm very happy to work with Olena on a daily basis within the ICC setting. And Olena is also president of Ukrainian Arbitration Association for a long time already, since 2016, and obviously she has many other commitments and titles. We also have on the panel today Pirik Legov, who is a partner at the École Florence, dealing mostly with arbitration, but not only, also with compliance issues and a variety of other points, and who was, before joining the École Florence, Pirik was also a group general counsel at Alstom Group, meaning that he has an extensive and very impressive experience as an in-house counsel in one of the biggest corporations in the world, also dealing in particular with the subject matter of our webinar. So Olena and Pirik, let us start. Just maybe as a starter, let's maybe cover what types of disputes the parties encounter in practice during the evolution of their construction projects, and how they're actually dealing with this. Maybe let's start with Pirik. Could you please expand on that?
Yes, thank you, Sergey. Hello, everyone. I'm very pleased to be with you today to join this discussion and work on a return of experience. I think that when we think about the standard types of disputes we can see in energy construction projects, I would say that on the one hand, we see disputes that are considered as the norm or as the cliche of construction disputes, which are linked to what we could qualify as the two main goals of major energy infrastructure project. The first one is for the project to be on time, because the owner of the project wants to start commercial operation and make money based on the guaranteed time schedule of the project. And the second one is the performance guarantees, because the owner of the project wants to make sure that the energy facility will produce at the guaranteed performance level. Otherwise, there are shortfalls in revenues. And as a result, not surprisingly, a large portion of the disputes turn around project delays or performance issues. Also because these two main goals of the project are typically sanctioned by penalties or liquidated damages, depending on the governing law, either delay damages or performance damages. This being said, when you look closer at a casuistic approach to the types of cases, there are many other issues that come up, and what I find fascinating is that quite often a dispute will start with a root cause which is extremely technical, and then during the progress of the dispute, the technical aspects of the dispute convert quickly into very legal topics. And I have two examples in mind. The first one is a case I had, which was referred to as the working time dispute. And the root cause of the dispute was the fact that on an energy facility construction project, the canteen for the employees to have their lunch at midday was built not exactly at the location provided for in the design of the plant. and it was a bit further away than expected. And as a result, during the lunch break, the employees had to walk longer to join the canteen and then walk back to like the control room and the other parts of the plant. And as a result, the owner launched a dispute to claim the loss of revenue linked to the disruption caused by the fact that employees were losing productivity because of this working time, which was additional. So that was at the start, obviously, I would say technical design dispute, because the question was the canteen at the right location? You had to check the design and so on. But in the end, the core debate of the dispute was the extent to which the claim for the loss of revenue was excluded through the consequential loss exclusion clause of the contract, because as is often the case in this type of contracts, you had a clause specifying that any loss of profit or loss of revenue or other similar types of consequential losses were excluded. And therefore, that was really the core of the debate. And what looked initially as a design issue quickly became a very legal topic. The other example I would have in a similar fashion was a case where some defects appeared in a heavy steel structure, again for an energy facility project. And the recommendation of the contractor was to remedy the defects, which were cracks in the steel, through additional welding. So it was more a repair activity than a replacement activity. And the owner demanded a full replacement. And therefore, there was initially a technical debate, which was whether the repair option or the replacement option were providing the same level of technical comfort, in terms of life expectancy of the facility, or in terms of performance of the facility. Would the difference in the technical remedy have an impact? And once this problem was solved, the legal issue surfaced, which was that the owner nevertheless demanded full repair as a matter of maybe comfort. And the contractor wanted to do only the repair activities. And the legal debate turned around the level of discretion for the owner to impose a solution, knowing that the full replacement solution was obviously more costly and was adding more time in executing the project, leading potentially to delay penalties, which means that issues that came up were good faith in executing the contract, potentially abuse of rights. And here again, you can see that a dispute that started with a very technical approach became quickly a legal dispute.
Thank you very much. And indeed, very relevant examples. And one thing I also noticed in my practice at the ICC that often there are several parties involved in construction. It's quite actually the norm now. And in particular, several members that form a consortium
Yes.
for a particular project, or for a group of projects, so to say. And could you please explain, also maybe from your in-house experience, are there often disagreements or some misunderstandings that evolve afterwards into disputes between the members of the consortium, and how they are actually solved before the matters escalate?
Yes, no, it's a very good point, because you are right that quite often, due to the size of these projects, even a big company is not always able or willing to do the project alone. And I think that with respect to consortium structure, you see two or three types of repercussion. The first one is I often see disputes which relate to scope definition or a scope interface, meaning that maybe some services or some equipment to be supplied for the project were not perhaps properly defined in the scope of works. And then you have a dispute between the consortium contractor and the owner as to whether or not some additional works are truly additional works or whether they were actually included in the lump sum price of the project. Obviously, this dispute at the start is between the owner or the developer of the project and the consortium. But then it quickly spreads as a dispute between the consortium members, because if in the dispute with the owner, the outcome is this additional services or equipment are to be viewed as being part of the scope of works which should be performed by the consortium, then you might have a dispute internally between the consortium members as to who has to bear the extra cost of performing some works or services which actually were not quoted in the contract price. But you could also have a situation where there is a delay on the project, and the outcome of the dispute with the owner is delay damages are imposed. And then internally within the consortium, you will have a dispute as to who is at the origin of the delay and whether or not the consortium clauses provide for a solidarity approach where you share collectively the outcome of the delay penalties. And I think here a standard procedural point which also impacts the contract drafting is the question of the stay of proceedings. Because normally, if these consortium agreements are well drafted, they will specify that if there is a dispute between the consortium members, which is dependent on the outcome of a dispute with the owner, then there will be a stay of the proceedings for the dispute between the consortium members until the outcome of the main dispute with the owner. And usually the clause will even go one step further to specify that the consortium members agree not to challenge the outcome of the main dispute. So if the outcome of the main dispute is the delay liability is with the consortium, and here is the amount of delay damages, then the consortium members agree that they will not rediscuss or debate between them this outcome. They will only debate the allocation between them. I think these are very specific features linked to the consortium structure. And it's also a good example where the experience on the dispute side will feed what should be drafted in the consortium agreements to have everything in place to at least manage efficiently this type of dispute.
Thank you, Rick. And this is actually exactly what we're seeing empirically in our cases at the ICC. First of all, we do see mostly, obviously, the most standard cases between contractors and subcontractors. From time to time, we see also the disputes that arise between the consortium members, only between themselves, and usually you will have some preceding dispute between contractor and subcontractor where the consortium was one of the parties. And sometimes, it's we see the mixture of what you describe. And indeed, it impacts a lot the final outcome of the case of the whole whole dispute, which might spread into several arbitrations that can last, each of them which can last for several years. So sometimes we have like dynasties of disputes that started in early 2010s, and some of them are still pending in big construction projects. Also energy construction projects. So it's quite interesting also because projects themselves evolve. So some disputes arise later on different points, and they cross connect, and often previous awards become, or one of the parties argue that they become res judicata, so that they should be applied as effect. while other parties try to refute that arguments. And then it's quite interesting to see, and it depends on applicable law, on contractual provisions, and on how the contracts were drafted. The outcome also differ based on all these factors. So indeed, I confirm that we also see it a lot empirically at the ICC as well. Olena.
Yeah, and I would like also to add that on the top of that, there are many different parties involved in the project. Yeah, so employer, contractor, subcontractor, suppliers, insurers, lenders, vendors. And they might have their dispute in different configurations altogether, or with some combination of them. And when there are some awards that could bring additional issues into subsequent proceedings, because the proceeding might develop in different venues and different times, sometimes in parallel, sometimes consequentially, and it also gives a bit of complexity. But what is also important for this project is that the projects are normally very long-term projects, and that means that the proceedings sometimes go in parallel with further construction made on the site, and that probably explains quite specific dispute resolution mechanisms for such projects, and designed, first of all, to keep the project going, despite all the disputes different stakeholders might have, and despite all that. And indeed, we could see, if we talk about different problems on different stages, it could be payment issues, it could be defects issues, that, as Pierre said, delays issues, concurrent delay issues, supply. So in recent years, we also, of course, see a lot of hardship and force majeure, especially not only in Ukraine, it's more broadly because of the COVID and some other issues. So we might see different issues arising. Then it could be something regarding completion and different issues of damages on either side of defensive claims. So quite diverse combination of factors, issues, etc., which are probably explained by the scale of the project, its complication, its technical complexity, because it really involves, as Pierre mentioned, many technical issues, and also the long term of the project. So this also, I think, contributes to all that, and different players involved. So that was my brief contribution on that.
It's a perfect contribution. Thank you very much. And actually, it's also a nice transition to the next sub part of our discussion, is the methods of dispute resolution that are available to the parties. Because obviously, as I'm myself being an officer of arbitral institution, obviously we see a lot of arbitrations, but this is only one of, and often the ultimate dispute resolution method when others previously failed. And here we're very lucky to have on the panel both, an expert very much also experienced as an in-house counsel in a big industrial group, who is now also practicing arbitration as a partner, and at the same time, a partner in specializing in international arbitration, mostly dealing with dispute settlement mechanisms. And my first question would be to Pierre, maybe. How could you please explain to us, also maybe from your putting your previous in-house hat, how do you see disputes evolving? Because it's quite rare in my view when the disputes directly jump in, when the parties directly jump into arbitration without trying to resolve the dispute amicably. And I'm sure that in big, important projects there are some, mechanisms and previous discussions not to escalate as quickly. And of course, we have formal mechanisms as involvement of project neutral, involvement of engineer. Then it can go further with DABs proceedings before it goes to arbitration. So I think it would be helpful for the audience to see how exactly the disputes are resolved and often prevented, like even in the earlier stages where it is of course possible, where there is no like drastic disagreement between the parties, and there is no need to involve the third party to resolve the dispute. So Pirk, could you please expand on that? Maybe first covering less, aggravated situations where maybe giving some examples how they can be solved without referring to DABs and arbitration, and then of course more classical that end up with us at the ICC with formal proceedings, formal representation of the parties. Yes, could you please?
Yes, sure. Maybe as an introduction to address this question, I could start by elaborating on some important points made by Olena about first the very large number of participants in this project. I think this is important because the more participants you have, the more potential diverging views and interests you can have in the project. And at the same time, as Olena emphasized, these are complex long-term projects. And as a result, not surprisingly, they are often qualified as quite exposed to the risk of disputes. If you read the literature, because obviously we are here to discuss practical and pragmatic views, but I think sometimes it's good to also have in mind in the background the scientific approach to the legal analysis of these projects. And there are a lot of articles which explain that because of the large number of stakeholders in this project, you have an increased duty of cooperation for the success of the project. In civil law countries, it's in a way a derivative of the principle of good faith, which includes this obligation to cooperate or the duty of loyalty between the partners. In the Anglo-American literature, sometimes it goes one step further, and you read, a notion of partnering where the scholars go as far as explaining that the parties need to behave as friends of the project. I think the reality on the ground is a bit different because there is a lot of money at stake usually when a dispute arises, and I think that quickly the notion of friends of the project is abandoned as perhaps too much a peace and love approach, and you come back to the reality of the financial figures and the financial impact. And I think this drives some aspects of what we see in the way in-house counsels and corporations will first try to approach this dispute. I think the classical approach, obviously, is settlement attempts, and this will be facilitated, I think, for projects where you have, this, project committees. I'm not talking about dispute boards. But quite often you will have a project committee which meets on a weekly or monthly basis, which gathers, heads of the project teams of each of the parties. And I think this is a first forum where disputes that are looming, will try to be pacified. But it doesn't always work. And here, I would say a point of attention, if we do the link between the practice and the disputes, is I've seen quite often in arbitration proceedings parties raising an argument of a disconnect between the scope of the settlement discussions and the scope of disputes being raised in the arbitration proceedings. because maybe if you take the example of a delay, a dispute will start around delay damages being imposed, and the contractor challenges the liability for the delay and therefore challenges the obligation to pay the delay damages, and therefore the settlement attempts will focus essentially about the payment or the non-payment of delay damages. And maybe these settlement discussions fail and the matter moves into arbitration. And when it moves to arbitration, the parties bring new claims, and they might bring counterclaims like, overdue payments, prolongation costs on the site, what have you. And then the other party might argue that all these new topics that have come into the arbitration proceedings were not part of the scope of the settlement discussion, and as a result, a party has violated the prerequisite for the obligation to hold settlement discussions before launching a dispute. So I think the first point of attention here is to have in mind this potential disconnect between scope of settlement discussions and subject matter of the disputes when it moves to arbitration or other forms of litigation. Now, what I feel in my experience has worked very well is technical expertise. I have had many cases where before moving into a full-blown dispute, the parties, mainly because it was specified in the contract, went first with technical expertise. And I have been positively surprised by the fact that quite often the parties will stick to the outcome of the technical expertise and will not necessarily challenge. And I think probably because they consider that the technicalities of the dispute means that a challenge in arbitration will perhaps not lead to something completely different. And they will use the outcome of the technical expertise to try to settle. And I think that the settlement will be facilitated by the fact that you have already some aspects of the dispute, namely the root cause, the technical root cause of the disputes will be already addressed. This being said, I've also seen, and I think it was also a pleasant surprise. I have seen mediation being used for this large-scale dispute. I would say 20 years ago, when I was discussing with colleagues in the industry, I had a lot of feedback along the lines, mediation works well for small contracts, small disputes, but for a large-scale energy construction project, it's too complex. And I don't think it's too complex. It's just that my experience has been that for small disputes and small contracts, you will have a mediation which lasts one afternoon. And for large disputes, large contracts, you will have a mediation which might last 1 week or more or several months. But it doesn't mean that it's impossible. The last point to raise, since you mentioned DABs or dispute boards, there is, for me, a paradox with dispute boards. Some intrigue that I have still not been able to resolve to date, and maybe it will be interesting to have your views if you have can shed some light. But I think that as a tool, as a concept, dispute boards are very efficient for one good reason, which was mentioned earlier by Olena, which is because the projects are long-term projects, you cannot just stop everything because you are in dispute. So it's very important to be able to continue the progress of the project while the parties try to solve the dispute. And that's really the core philosophy of dispute boards. And because it's permanently established, it's quick. You have usually a good diversity in the dispute board. Sometimes you have a mix of lawyers, engineers. So I would say on paper, it looks very good. And when it is implemented, my experience is it works very well. The paradox I was referring to is that if you compare the use of dispute boards with the number of energy construction projects in the world, I think there is a disconnect. In other words, based on what I have explained on the efficiency, you would expect to see dispute boards all over the place, and they are not all over the place. And the main explanations I can see here are quite often it may be difficult for the parties to go through the hurdle, the psychological hurdle of already specifying early on in the project a dispute mechanism when, from the parties' perspective, they are not yet in dispute. And very often I had the comments when I was raising the idea of injecting a dispute board in a contract, operational people saying, "Well, look, we have not even signed a contract, and you are already planning disputes. So you are, completely pessimistic. And if we want to invest money, let's invest money on the project, and let's not invest money on establishing a permanent tribunal when we don't even know whether there will be any disputes." That could be one explanation. Another explanation is because it has a cost from the beginning, and because parties are under economic pressure, they want to win the project and so on. I think that when they believe that they have money to invest in dispute prevention, they will probably want to invest first on staffing their claim management and contract management. They will prefer to staff more internally with contract manager, claim managers who will be part of the project team, as opposed to spending money on establishing a permanent dispute board. Now, these are my explanations to try to explain this paradox. There might be other explanations, but in a nutshell, I think it works well, but I'm surprised that it's not used more often.
I could also just agree that I would also expect that the financial aspect is one of the important aspects of that. And in Ukrainian realities, I know that sometimes mainly financial aspect stops the parties from agreeing for standard multi-tier dispute resolution procedure. And sometimes, as a solution to it, the lenders financing the project, they finance this part of the dispute resolution, because they understand that it's really important to keep the project ongoing and to have the effective dispute resolution mechanism. So sometimes the lender financing is paying the fees for the AD as well. And probably another reason is that not all the construction projects are FIDIC projects, yeah. And they sometimes, I have seen quite many which were, not based in FIDIC, and or probably somewhere in the very beginning there was some inspiration from FIDIC, but it was so, it was amended and in a way that quite many provisions, not only on dispute resolution, but generally were changed. And that's why the dispute resolution clause might look quite differently. And sometimes, additionally, again, what I have seen in arbitration was the parties explain why even having the multi-tiered dispute resolution clause, they have not created for some reasons properly DAB, because one of the parties did not cooperate, or for some other reason. And that explains why there are more arbitrations probably than, and why there are less dispute boards as effective dispute mechanism, dispute resolution mechanism. And yet another reason might be very regional specific. Sometimes you do not simply have enough professionals with the language capacity, with proper training, etc. Especially if the parties decided, to include into the contract that the I don't know, adjudicator should speak particular language, or be experienced in construction disputes or something else, and that reduces the pool of potential candidates to the extent that the parties are not able to agree on those few who qualify. So, but I agree that it's a really amazing and very efficient dispute resolution mechanism, which probably could even be borrowed to some other industries as a very good examples of standing. It's not like one mechanism for one dispute is a standing available during the life cycle of the project mechanism, when the parties should not waste their time to appointment or negotiation. Only once, for its constitution, and then they could use it on day-to-day basis for smaller or bigger issues they might encounter during the project. So that was my explanation. Oh, I guess, I don't know if it's true.
Very useful. Thank you very much, Elena. Indeed, just maybe to comment from this institutional perspective, we see, because obviously it's like in a way a survivor's bias, we only get cases that progress to arbitration. So we don't see those that are settled previously through other means. But when we see, for example, disputes based on multi-tier dispute resolution clauses that often start with, as Pirik mentioned, with meetings of project committees on the level of the management. We sometimes see, for example, admissibility objections by one of the parties that try to show that there were no such meetings and that another party decided to escalate directly to arbitration. We also see sometimes parties trying to skip DABs altogether, even though they're provided by dispute resolution clauses. Then it depends on the applicable law, how it evolves. In some jurisdictions, there is already some established court practice on this point when the matters are, when the arbitration is actually stayed, and parties are required to come back and form a dispute board for trying to resolve the matter. I had personally such a case where the proceeding was stopped like that. And then potentially that might be over for the arbitration, because potentially the parties will just comply with the AB decision and then it's over. In my case, parties came back and the case is going forward. So, for example, it depends really on the situation, on the willingness of the parties to cooperate, and on facts of the case. But indeed, it's one of the, especially in bigger projects, we often see contracts providing for the DABs, and often the arbitration itself is actually, is addressing the points whether the dispute board decision was correct or not, and because FIDI contracts provide for this opportunity to reevaluate the dispute from starts, and some parties use this. Also on cooperation and this duty to cooperate, what I noticed in my pre-institution practice, also in Ukraine and abroad, is that it also depends sometimes on the contractual power, so to say, and whether one of the parties has a monopoly in some sector. For example, in energy production sector, it could be sometimes the case where there is a state monopoly with, for example, atomic power plants or some other power plants controlling those. And then they have contractors doing, some construction works for those plants. Often what I've seen in practice, what happens is that a contractor who understands that if they actually damage their relationship with the only monopoly they have, they might be just out of business. So that's why sometimes we see cases settling, even though they could actually try to fight, but they feel like that strategically it's better to settle and maybe lose some money on this particular, project in order to continue the business and have other, engagements, other involvements, other projects coming later. So it's often not really legal, it's more business-like, strategy for some contractors to approach those disputes. So that's what I've seen as well. And now maybe it's time to move to discuss maybe some trends in arbitral proceedings in construction, energy construction disputes. And the one I wanted to ask, because we have a perfect panel for that, we have two established practitioners, one focusing on Eastern Europe in the region, and another one more on Western side of the world. So what could you mention as maybe some trends in terms of subject matters of the disputes? So, for example, if there are any trends on, for example, those related to transition of natural gas or renewable energy or some other types of disputes, if you could comment on that, maybe let's start with Pirik.
Yeah, I think one main trend, and I will only give one example, which we have seen, I would say in the past 2 or 3 years, is on the one hand, obviously material price increases and supply chain bottlenecks. Supply chain bottlenecks arose mainly from the COVID and post-COVID era, because even that was perhaps a bit of a surprise or not, but obviously it was relatively obvious that the heart of the COVID crisis and the lockdown periods were going to create bottleneck issues in supply chain and supply chain disruptions. However, we saw post-COVID that the resurgence of economic activity created the same bottlenecks, but not because factories were at a standstill, but because factories were overwhelmed by the demand. This was combined in a way in a transition phase with geopolitical events at large, creating other types of disruptions, combined with a third element, which is the major comeback of inflation. So we have seen, especially on energy construction projects, a rise of pre-arbitral claim situations, heavily driven by debates around hardship. I guess that's not a surprise, but also around, and it's more maybe a contractualization of a hardship, but around contract price adjustment clauses, and especially price index evolution clauses, where parties were, or at least one party was dissatisfied with the level of protection that price adjustment mechanism were providing in the face of the severe economic disruptions. And this was driving claims for extra time, claims for extra cost on the one hand, and obviously the other party taking the view that the contract is a turnkey lump sum construction contract, and that there is no room for contract adjustments, and some debates about the extent of the force majeure impact, and so on and so forth. So I think this, clearly is a visible trend we have seen in the past 2-3 years.
If we talk about the types of the disputes first, I would fully agree that there are to large extent either extension of time or delay damages, or like the hardship, force majeure, or unduly burdensome, unduly expensive projects. This all, if we couple the problems we now encounter in Ukraine, for instance, we have also some, and probably that was also for COVID, the dispute about some early termination, when the parties So one of the parties understanding the situation, wants to terminate, sometimes unduly, and then the parties have a dispute whether the contract was terminated or not, with the respective consequences. There might be also interesting issues related to so interesting employment issues. I mean, regarding the staff and especially during the COVID, when it was not so easy to travel and to reach the sites, the construction sites. There are also some regulatory issues, either driven by different considerations related to COVID or geopolitical situation. But in Ukraine, we also have security issues. It is not unique. I mean, there are many other places in the world where there are security issues, and there are some contractors who are like assume these risks when or are more keen to assume those risks and working in difficult jurisdictions, understanding all the benefits of it. But again, sometimes the measure how to understand the security threat is not also that easy, because in Ukraine you might have a project on the front line, on the occupied territory, or in Kyiv, or some other regional centers, even in somewhere in Lviv, and the evaluation of the situation would be quite different, as you could imagine. But still, they might be difficult logistical issues. So, you know, previously, or if you don't know, so previously, the major part of export and import of large equipment went via sea. And now the seaports are almost blocked. So there is a certain movement ensured by Ukraine after the collapse of the grain corridor, but it's not comparable to what we had before the war. And this really also a bottleneck for all the supply changes, as the only alternative is via the cars or rail. We don't have aviation again, so that means that we have only cars or rail to that. And sometimes for energy projects, at least for you might need to deliver like really huge objects, which is not that easy to put into a car or into a railway wagon. So it's also quite I mean, specific feature I would mention. But if we turn back to the question of Sergey, I mean, it's to the probably more industry specific rather than claim specific. Yeah, so probably the majority of disputes I have seen were related to construction of different power plants, either in renewable energy, including hydroelectric power plants, and in some, I mean, it might take decades for what I have seen with some huge hydroelectric power plants, and there might be series of arbitration, one going after another. I have also, so it also could be with regard to storage capacity or pipelines or otherwise delivery of the energy. And so sometimes in some regions more to oil and gas, and sometimes more with renewable aspects. And last but not least, it might also have investment treaty aspects related to regulatory issues, green tariffs, etc., etc. And again, several jurisdictions in Europe are quite famous in that regard. Ukraine has its small contribution in that as well, but it's settled in a way or prevented, better to say, many disputes, and then because of the war it all went wrong, because the majority of those projects are in occupied territories. But otherwise, I would say that this is power generation, storage, and delivery, so to speak.
This is basically what we also see on our end and the ICC in terms of cases that we receive. Thank you. And let us maybe now move to the procedural aspects of this discussion. Do you see any procedural either differences or maybe trends in disputes related to energy construction projects, maybe based on their size, for example? So I can share what we see at ICC. Those bigger, more complex arbitrations where you have hundreds of millions at stake, sometimes billions, often they are, first of all, based on FIDIC contracts, not always, but either FIDIC-based or FIDIC-like contracts when they take as a basis, but then they made and alternate as they want. In these disputes, usually you have global arbitration firms representing the parties, and the proceedings are often done in most, so to say, standardized way, where you have, introductory submissions, then first rounds of submissions, then it moves into document production phase, then you have some expert reports, then you always have a hearing, sometimes that can last several days or a week or more, and then you have post-hearing briefs, and then the arbitral tribunal, unless there is also some jurisdictional objections, then you have the jurisdictional stage as well, and then it moves into final award stage, as opposed to smaller cases on some regional projects where, first of all, parties often draft their own contracts for specific projects in a quite unique way, not applying any pre-drafted forms like FIDIC or etc. And then you have, so to say, a smaller, shorter procedure, often that does not involve document production phase, or a shorter hearing, if at all. So I just wanted to see what is your experience in this regard. Do you see similar situations as I described, or depending on your areas of practice, that actually not really applicable? I wanted to know your views on that. Maybe this time let's start with Elena.
Okay, I have seen different combinations. I mean, you are right in terms that the bigger the project is, and especially if a lender, some reputable financial institution is involved, you are more expected to see FIDIC, more or less standard FIDIC-based contract with and with subsequent representation, as you described, as a long proceedings, because you have many issues. So because you normally you have sometimes multi party, sometimes again multi-issue arbitration, because construction is very known for having many disputes considered simultaneously, and quite often the parties, like, they collect several DAB decisions and then take a package and go to arbitration, not one by one, because it's cheaper to consider them in packages, so to say. And with that package, they come to arbitration, and in arbitration, the arbitrator have to deal with all these smaller disputes, either in parallel or one by one, and that explains the complexity of procedure, and some quite often involving technical experts, engineers, quantum experts, etc., etc. So it's not that easy for an arbitrator to understand whether there was delay or not. Whether some calculation is correct or not, because sometimes the rules are really so specific that only parties may understand how it works. I mean, and I have even seen the cases when the parties wanted to calculate the amount themselves. They wanted the tribunal just to establish, so to say, the rule, or to clear the rule how this should be, whether there was delay or not, and then they were going to calculate themselves, because especially with this consortium, etc., that might be quite complicated. It's also interesting that if a state party, a state entity is involved, that might explain some additional problems or additional specificity of the contract and dispute resolution clause, and then representation issues and procedural issues. Because first, state parties prefer to save money, or to not to spend money to some extra steps, which means that they might insist on skipping DAB. They might insist on like simplifying in a way the dispute resolution procedures. And then if they are self-represented, then they quite often do not have either capacity or knowledge to fully act in a long and complicated procedure. But no, it's not always so. There are some very like experienced and qualified teams with I don't know, hundreds of cases in their portfolio, knowing exactly what to do even in quite a complicated proceeding. So it's not a general rule, but I have seen that sometimes when the state agency itself represents, it's more like streamlined. And it's quite often not multi-tier, and that's why it might be just negotiation and arbitration, that's it. Another aspect, again, sometimes it's not FIDIC at all, it's something sui generis, with, again, involving state entity as well, because they probably looked at FIDIC, decided, oh, no, it's too expensive, and then they created their own mechanism, which is not necessarily less expensive. It's just different, sometimes quite complicated or difficult to implement, but they have what they have, and sometimes involved in the insolvency of one of the consortium member and dragging all the dispute resolution to different sides and directions. So just to sum up, it might be very diverse, and I would agree that for small cases it's never FIDIC, but for big cases it's not always FIDIC as well. So to say.
Exactly. Pirik, any views on that?
Yeah, I think from my perspective, the main trend I see, and moving indeed into procedural matters, is the question of extension of arbitration clauses and consolidation of arbitration clauses, because as we said earlier, there are a lot of project participants, and as a result, there are a lot of contracts. Many of the contracts are interconnected for projects which are project finance with involvement of lenders. You will typically have direct agreements between the project company and the contractor with step-in rights. You have quite often the developers which will set up a special purpose company to run jointly their activities. And as a result, quite often this leads to either a request to involve a party which was not a signatory of the main contract in dispute. And then the question will be whether this party was involved or not in the negotiation, in the supervision of the project. And if it's more consolidation, then the key questions will be whether there are elements in the different arbitration clauses that create a stumbling block because they make the arbitration clauses completely incompatible, which would be the case if the seat of the arbitration is not in the same country, or the number of arbitrators is not the same, and so on. But if there is enough compatibility between the clauses, it's more feasible. But I think the main impact on the procedure is that when you have this type of dispute at the start, with first deciding who are the parties to this dispute, it can lead to a bifurcation as a consequence, and you will have potentially a phase on the jurisdiction before having a phase on the merits of the case, and as a result, you have at least 2 awards. And it makes longer procedural times and added cost on the proceedings.
This is true. This is what we also see quite often in the ICC proceedings. With regard to consolidation clauses, there is also a big variety of those that we find in the contracts when they end up with us. Sometimes you have just direct referral to a particular in one agreement to another, so to say, where it says in case of any disagreements, the dispute should be resolved through the arbitration, and then refer, for example, to a framework agreement that encompasses all other sub-agreements in a particular project. Sometimes parties really try to separate the disputes to make sure that one does not end up in a dispute where it's not supposed to be. And sometimes this is where often the court steps in, is the gray area, indeed, where you have some kind of arbitration, they have some different arbitration clauses, and then one party tries to argue, okay, there is a common transaction under which the project might fall when we apply the terminology of ICC rules. Exactly as you described, then they rely on, for example, same or different places of arbitrations, which then have direct impact as to applicable procedural, of course, lex arbitri. But even when many points of compatibility actually are checked, another thing is about the timing of filing of the requests and different stages of the proceedings. Because one of the elements under the ICC courts analysis, but also in other institutions, and I guess also for the state courts, is whether the stages are still compatible. Because if you have one case which just started and another one is already approaching the final award, it would not be economical, to postpone the first case in order to wait until the second case advances to the stage of the first case in order to have a common final award. And for these reasons, the deciding authorities, which could be ICC court, but also national courts, or whoever has to decide on parties' requests, and ad hoc arbitration should be tribunals. They will also assess this, economic efficiency and procedural efficiency, because otherwise parties will be denied justice by waiting. And obviously, time is money, and it can have direct monetary impact on a particular case. And so I completely agree with both of you. It's often an issue that arises in proceedings and must be addressed at the stage of contract drafting, because afterwards it's a bit too late for the parties to argue. Yeah. Thank you. I think we exhausted our time, even surpassed a little bit of an hour that we announced. So we have to finish this discussion on this note. I think we covered all the important elements of how the case proceeds. Another topic which might be discussed, just to mention to the audience, this is the first webinar of the series of webinars on energy and energy law done by ICC Ukraine. So we have others in the row. So as a suggestion to the future speakers, you can also cover the compliance with award and enforcement proceedings. I think it's also an important topic to be touched to complete the discussion, as we covered already the pre-arbitration step, the arbitration. That's another part to be covered. And I would like to thank Pirik and Anna for this wonderful discussion and for this contribution. I'm sure the audience really liked it. And this webinar will also be available afterwards on YouTube channels of ICC Ukraine and Ukrainian Arbitration Association. So everyone who is interested and who could not join us at this moment right now can watch it later. Thank you very much and have a nice day.
Thank you.
Thank you.
Bye-bye.
Goodbye.
Bye.